government may not regulate individuals' possessions of weapons for self-defense.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself.
Businesses are welcome to put up signs that say this is a gun-free zone, but if you don't, then it's expected that you are able to carry on that property.
This case could reshape how far states can restrict your right to carry and where.
The law the Supreme Court justices have their eye on is one that prevents people from carrying guns in certain public places.
The Supreme Court just issued an emergency ruling that's sending shockwaves through every state capital in America. This isn't just another court decision. It's the complete dismantling of gun permit systems as we know them. And here's the twist nobody saw coming. The Department of Justice isn't fighting it. They're actually supporting it. What started as one state's attempt to sidestep federal law has now triggered the biggest Second Amendment upheaval since the Bruen decision. The ripple effects are already hitting law enforcement, state budgets, and millions of Americans who thought they understood their rights. By the time this ruling takes full effect, the entire landscape of who can carry, where they can carry, and how they can carry will be completely transformed. Let me take you through exactly how we got here, because this story reveals something much bigger than gun rights. It's about what happens when states try to turn constitutional guarantees into government-controlled privileges. After the Supreme Court's Bruen decision in 2022 struck down restrictive, may-issue permit systems, most states grudgingly adjusted their laws to comply. Hawaii took a different path. Instead of accepting the court's directive, they engineered what constitutional scholars are calling the most aggressive workaround in modern legal history. Between 2022 and 2024, Hawaii's legislature passed 14 separate laws that created a permit system so restrictive it essentially banned carrying firearms while technically maintaining a licensing framework on paper. The centerpiece of their strategy was breathtakingly simple, yet devastatingly effective. They declared that 99.8% of all private property in the state was automatically off limits to anyone carrying a firearm unless they first obtained written permission from every single property owner. Think about what that means in practice. Want to carry your legally owned firearm to the grocery store? You need written permission from the store owner. Driving to work? Better have permission from every business you might pass through. Going to dinner? Permission required from the restaurant, the parking garage, and anywhere else you might step foot. Internal communications obtained through public records requests revealed something even more damning. Hawaii officials knew exactly what they were doing. Emails between the Attorney General's office and legislative drafters explicitly discussed creating functional prohibition while avoiding immediate federal intervention. They weren't trying to comply with the Supreme Court. They were actively scheming to circumvent it. This calculated defiance might have worked if not for what happened next. When the Department of Justice filed their brief in December 2024, it sent shockwaves through the legal community. The federal government switching sides in a Supreme Court gun case had happened exactly twice in 4 decades. This made 3. The DOJ's 47-page document didn't pull any punches. They used the word pretextual 4 times, legal speak for calling someone a liar in open court. Even more stunning was their request to participate in oral arguments against Hawaii, something the Solicitor General's office almost never does in state-level disputes. Their brief systematically demolished Hawaii's position with 23 separate historical analyses. No permission-based system like Hawaii's had ever existed in American history. Not during colonial times, not during Reconstruction, not even during the strict firearms regulations of the early 1900s. The federal government was essentially admitting that these laws couldn't survive constitutional scrutiny. Within 72 hours, the implications became crystal clear. If the DOJ itself was declaring these restrictions unconstitutional, every similar law across the country just became legally indefensible. The state-level response was swift and unprecedented. When Texas Attorney General Ken Paxton filed the first supporting brief in November 2024, it triggered an avalanche. Within 6 weeks, 25 additional states joined forces, creating a legal coalition representing 168 million Americans, more than half the country's population. This wasn't just red states rallying around gun rights. The coalition included New Hampshire, which has never required carry permits in its entire history, alongside states like Ohio and Indiana that only recently adopted permitless carry. Their combined argument went far beyond firearms. These states raised an alarming point. If Hawaii can flip a constitutional right from allowed unless prohibited to prohibited unless allowed, what stops them from doing the same thing to free speech, religious practice, or any other protected right? Montana's brief included a particularly chilling analysis showing how Hawaii's logic could theoretically require written permission before attending church services or speaking at privately owned venues. By January 2025, this state coalition had submitted over 1,200 pages of evidence and analysis. Their message was unmistakable. This case threatened the very foundation of how constitutional rights work in America. While lawyers battled in courtrooms, something remarkable was happening on the ground. 127 lawsuits across 9 states are currently frozen, all waiting for the Supreme Court's Hawaii ruling. These aren't copycat cases, they're challenges to similar restrictions in California, New York, New Jersey, Maryland, Illinois, Massachusetts, Connecticut, Rhode Island, and Delaware. The coordination is staggering. The Firearms Policy Coalition alone is managing 31 cases with a combined legal budget of $18.7 million, all allocated based on the assumption that Hawaii will lose. The Second Amendment Foundation has 22 cases representing approximately 47,000 plaintiffs who've been denied permits or charged under similar laws. Discovery documents leaked from New York's Attorney General's office show state officials openly discussing worst-case scenarios where they'd have to completely rewrite their regulatory framework within 90 days of an adverse ruling. That's not speculation, that's their own timeline. But perhaps the most telling sign of impending change comes from law enforcement itself. In January 2025, sheriffs from 19 California counties issued a joint statement that stunned the law enforcement community. They announced they would no longer proactively enforce permit requirements unless someone was actively committing another crime. Their reasoning was brutally practical. If the Supreme Court strikes down Hawaii's law, every person arrested for permit violations could file federal civil rights lawsuits. The potential liability exposure was estimated at $340 million if just 15% of recent enforcement actions resulted in successful suits. A December 2024 survey found that 62% of police chiefs across 8 restrictive states had issued internal memos instructing officers to use maximum discretion on permit violations, code language for don't enforce unless absolutely necessary. District attorneys in 14 counties dismissed 1,847 pending charges related solely to permit violations. Cook County, Illinois alone dropped 412 cases after determining the legal risk outweighed any public safety benefit. The economic implications are equally staggering. Permit systems created an $880 million industry that's now facing extinction. In 2023, permit-heavy states generated $216 million in direct government revenue from fees alone. California brought in $47.3 million, New York collected $38.6 million, and Illinois pulled in $29.4 million. The mandatory training industry surrounding permits generated an estimated $680 million annually. 3 major training companies have already filed for bankruptcy, citing anticipated regulatory changes. Hawaii's own permit processing division shrank from 47 employees to just 19 as applications plummeted 78%. But beyond the money, there's a human cost. Approximately 340,000 Americans applied for permits between 2023 and 2024 under systems that might soon be unconstitutional. They paid hundreds of dollars in fees, completed expensive training courses, and waited up to 14 months for approval. Now they're stuck in legal limbo. New York has 67,000 applications frozen in processing. California has 89,000 applications with wait times that ballooned from 120 days to 287 days. Applicants receive form letters referencing ongoing litigation affecting regulatory framework. Bureaucratic speak for "we're waiting to see if these laws survive." The absurdity peaks in Hawaii, where 47 people who completed the entire permit process are now receiving letters warning that their permits might not be legally valid for carry on private property, the exact provision being challenged at the Supreme Court. What makes this particularly revealing is the real-world data from states that have already eliminated permits. 29 states currently operate under constitutional carry, with 21 making the transition since 2010. The results contradict every dire prediction. FBI data shows violent crime decreased an average of 8.2% in the 3 years after states adopted constitutional carry, compared to just 2.1% in permit-required states. Maine's gun homicide rate actually dropped after eliminating permits in 2015. New Hampshire's rate of 0.9 per 100,000 makes them the second safest state in America. Vermont, which has never required permits in its 233-year history, consistently ranks among the safest states nationally. The data reveals an uncomfortable truth. Permit requirements create bureaucratic burdens for law-abiding citizens while doing nothing to prevent criminal misuse, since criminals don't apply for permits anyway. At its core, this case asks a fundamental question. Do constitutional rights begin with citizen liberty or government permission? Hawaii argues that property rights allow states to flip the Second Amendment's default from allowed to prohibited. But legal historians found zero historical examples of permission-based systems for exercising constitutional rights. The closest example was an 1870 Tennessee law requiring pistol permits, which Tennessee's own Supreme Court struck down the very next year as incompatible with the concept of a right. Hawaii's property rights argument crumbles under scrutiny. Property owners already have full authority to exclude armed individuals through trespass laws. If Hawaii's logic survives, states could require permits for religious services, government approval for public speaking, or bureaucratic permission before refusing home searches. The Supreme Court now faces a choice that will echo for generations. They must decide whether states can redefine constitutional rights through clever wordplay and permission schemes, or whether they'll reaffirm that rights belong to citizens first, with government power to regulate coming second and only within historical boundaries. As this decision looms, we're watching the real-time collapse of a permission-based system that millions of Americans have lived under for decades. States are rewriting laws, law enforcement is abandoning enforcement, and an entire regulatory industry is crumbling before the final ruling even drops. The transformation is already underway. By the time the Supreme Court's decision takes full effect, the question won't be whether you need government permission to exercise your rights. It will be how quickly states can adapt to a reality where constitutional guarantees actually mean what they say. That's it for today, folks. See you in the next video.